So I'm going to cover another product liability video here today. And what I'm going to do, I'm going to go over a recent case from the Supreme Court of Ohio, and it deals with what is considered a supplier for purposes of Ohio's product liability statute. Under this statute, I went over the basics in a prior video, but just as a refresher, the Ohio product liability statute is meant to provide some recourse to consumers against manufacturers and suppliers of products. In this case, coming out of the Supreme Court of Ohio, is really all about what is considered a supplier, who qualifies as a supplier. So let me just get into a little bit of background from the case first. The name of the case is Stiner versus Amazon.com Inc. It was decided on October 1st of 2020. The slip opinion number is 2020-Ohio-4632. And it's sort of a tragic case. It arises from the death of an 18-year-old boy who ingested a fatal dose of caffeine powder. His buddy had bought this caffeine powder on Amazon.com. Buddy gave some to his friend. Unfortunately, it was a fatal dose, and the estate of this 18-year-old sued Amazon. I think sued the manufacturer and a few other companies. But basically, when it comes to Amazon, the estate of this boy who had died, that was arguing that Amazon is a supplier under Ohio's product liability statute. And under that statute, a supplier could be held liable under certain circumstances if that supplier was negligent, or if the supplier made some representations and the product didn't conform to that representation. There are a few other instances in which the supplier can be held liable, but the first thing that a plaintiff needs to prove is that the company that sold the product was actually a supplier. In the way it worked in this case, the seller of the caffeine powder was actually a third-party vendor. Amazon.com didn't sell it. This third-party vendor used Amazon to sort of facilitate the transaction. The company posted the product on Amazon and sold it through Amazon, but it wasn't an Amazon product. It wasn't being sold by Amazon. In the way I understand it that Amazon works, there's sort of two ways for these third-party vendors to sell their products. There's the marketplace, and then there's the fulfilled by Amazon. So the marketplace, which is what happened here with this caffeine powder, the third-party vendor is responsible for this almost a complete sale. The third-party vendor holds on to the product, warehouses the product, is responsible for packaging and shipping the product. Basically, Amazon does not touch the product whatsoever. It just sort of facilitates the online transaction. So that's what happened here. The other way for third-party vendors to sell on Amazon is the fulfilled by Amazon. And the way this works is a third-party vendor pays Amazon a fee. Amazon warehouses these products at its fulfillment centers, and then when a consumer purchases the product on Amazon, Amazon is responsible for packaging it and shipping it to the consumer. But that's not what happened here. This was a marketplace transaction. Amazon had no possession of the product whatsoever, didn't package it, didn't ship it, didn't do anything. And so the big question was, with these marketplace transactions, can Amazon be considered a supplier under Ohio product liability statute? And basically what the Ohio Supreme Court said was, in order to be a supplier, a company must exert some control over the product. That's a prerequisite to be a supplier under Ohio's product liability law. And because this was a marketplace transaction on Amazon, and Amazon had no control or possession of the product whatsoever, Amazon couldn't be a supplier under Ohio law, and therefore the claim against Amazon under the product liability statute just failed right off the bat. Amazon's not a supplier, can't use the product liability law to hold Amazon liable in this case. And it's pretty interesting because there's a provision from the opinion that I'd like to note, and it comes from the very last paragraph of the decision, the conclusion. And it says, under the facts of this case, we find that Amazon is not a supplier. So it'll be interesting to see if another case against Amazon happens to go up to the Supreme Court that involves a fulfilled by Amazon transaction, to see if perhaps the Ohio Supreme Court will hold differently in that case, where Amazon actually takes possession of a product and is responsible for packaging and shipping it. But unfortunately, the tragic facts of this case didn't play out in the estate's favor. But it's certainly something to keep an eye on for the future. And it should be noted that, you know, even if Amazon was deemed a supplier here, the estate would still have to prove that Amazon was negligent, or that the product didn't conform to our representation. They'd still have to prove the actual case. Just because Amazon could be considered a supplier in certain circumstances, or any other company for that matter, you still got to prove the injury and the relation to the case, and prove the elements under Ohio's product liability statute. So one thing to note is that just identifying a company as a supplier or a manufacturer is always the first step of a product liability claim, and then you go from there. In this case, the consumer, the estate of the boy who had passed away, failed right off the bat when the Ohio Supreme Court ruled that Amazon.com was not a supplier in this case. So we'll have to see how things proceed with possible future litigation, but things went Amazon's way this time.